But we're going to talk a little bit about, if we can get this to work, advanced healthcare directives. Everyone needs one. As a respiratory therapist, I saw so many times family members, patients that went through unnecessary suffering. You can go to a webpage. I'll show you where you can get this. You can Google it online. Anyone could get an advanced healthcare directive. The neat thing about the advanced healthcare directive, it's only 4 pages long. But if you Google it online, the instructions are 10 pages long. Okay? So, we're going to turn around. You're going to put in my healthcare agent. You're going to put in an alternate agent. You're going to turn around and say what authority that agent may have. The neat thing is you can nominate who you want to be a guardian or a conservator. You can help your family members. You can help your patients with this. You can go in and you pick all the options you want as far as what kind of care you want or what kind of care you want to withhold. It's all right there. The most important thing I wanted to talk to you about is not that line, but this line right here, this signature line. When I worked at this hospital, it was so funny. We would actually have patients that did not have these, that were being admitted. This was back in the 80s. That were being admitted, and we had to have them witnessed. And these are the people who cannot witness. Now, you tell me if there's anybody else left on the face of the earth when we get finished with this, okay? You cannot have someone who's related to you by blood or marriage. Stepkids, spouses, cousins, no family members, none, okay? You cannot be entitled to any portion of your estate, so no remote heirs. Nobody that's named as your caregiver. Nobody that is going to be providing health care for you. So the health care social worker that works for the home care company, they can't witness it. That really neat chaplain that works for the hospice company, they can't witness it because technically by law, they're providing care for you. They also cannot be a beneficiary of your life insurance policies, your trust, your retirement plans. They can't be payable on your accounts. Is there anyone left? Who?
I went to the bank.
Yes, the bank, the credit union, your neighbor, the visiting teacher that comes over to your house, your pastor, somebody. Now at the VA, the neat thing is if you get one of these at the VA and you fill it out, they have their chaplain come over or one of their social workers and they witness it. And I asked them, how can you do that? It's specifically forbidden. And the VA says, we're federal. And so federal law trumps state law and therefore they do it up there. But technically, I've had everybody, spouses, friends, neighbors, everyone witness these. Normally it never becomes an issue. But that one family member, we've got that one kid in the family, you know, that one problem child. I have 6 kids, and I tell them I have one problem child. They take turns being that problem child. They pass it around. Some of the kids do it more often, though. Okay, so if you need an advanced healthcare directive, they're free. This is my webpage. It's sniderlaw.org. You go over in the little corner right over here where it says resources, first page. If you click on resources, you can get advanced healthcare directives, you can get a power of attorney, a medical power of attorney, you can download them, they're free. You can just fill them out. Yes?
Could you go back to the website, please?
You bet. Just sniderlaw.org, click resources. I do this because I used to work in home care and hospice. I was a CEO of a couple of home care and hospice companies, and I did a lot of interaction with case managers at the hospitals, and they call all the time, Kent, I need a power of attorney. I got this patient here right now. They got a family member. They're going on an event. I need somebody here now. And I go to my webpage, click this. That's where you can get them. Also, post forms. I'm a huge fan of post forms because I've actually worked out in the field and worked in emergency health care. And I've been that guy, the first guy through the door. And the family member's going, no, they have a health care directive. They have a health care directive. We'll talk about that, okay? So that's where it is, sniderlaw.org/resources. You can go there, financial powers of attorney. There's even instructions on how to fill out a post forms and who can sign them. Did you get that? Did I click too fast? You got it? Okay. Powers of attorney, durable versus springing. I talk about this just briefly, okay? Think of a springing power of attorney. A durable power of attorney goes into effect now. A springing power of attorney goes in effect sometime in the future when something happens. And I tell my clients all the time, think of a jack-in-the-box. A jack-in-the-box is not a toy. A jack-in-the-box is a box. It doesn't become a toy until something springs out of the box, and now it is a toy. So a springing power of attorney is like that. It's a piece of paper which has no authority whatsoever until an event happens. Usually it says, my physician says that I am now incapable of financial, I'm incapable of managing my funds, I'm incapable of making medical decisions. There has to be a springing event. A durable power of attorney goes into effect the minute you sign it. And how do I know, as a health caregiver, what do I look for? I look for language that says, we'll talk about it, this power of attorney shall not be affected by disability of the principal. They usually will say that somewhere in the form. That means it went into effect right now. That means it's a durable power of attorney. It stays in effect. Does anyone know how long? How long does it stay in effect?
Until death.
Until death. Yes, I get people all the time, oh, I got a power of attorney. Mom died 6 months ago. I've been paying all our bills. And I'm going, don't do that. That's against the law. Okay? The minute they die, you lose your authority. Thank you. You are correct. Okay? The other thing is what happens as the patient, you're right at Alzheimer's, and I don't know why everyone thinks the constitutional law applies to Alzheimer's units, but they always stand at the door, kicking the door. You can't keep me, I have constitutional rights. If a patient revokes it verbally, you as a health caregiver cannot honor it any longer. Okay, now of course you can redirect the patient and they'll forget about it, or you can help them understand why they have it. But if you're trying to admit someone to an Alzheimer's unit or a long-term care facility and they're capable of saying, no, I want to go home, they're revoking their power of attorney. So then what do? We'll talk about that, okay? You have to have capacity to execute a POA. What is capacity for a POA? Anybody know? Because I get this all the time. I go over to IMC and over in shock and trauma, and I talk to a patient who's on a ventilator, or I go over to Salt Lake Regional Hospital in their ICU unit, and I talk to a patient who's intubated. If they can blink their eyes and answer yes and no, and they understand two things. Do you understand you have certain rights? Do you understand that you have the right to make decisions about your health care? If they can blink their eyes yes, they're good. Okay, do you understand that while you're here, someone needs to pay your bills? Yes. Who do you want that person to be? And I always lead them, you always give them, do you want it to be this person? Do you want it to be your daughter? If they say yes, that's capacity for power of attorney. So I'm happy to come do one. Or you can go to my webpage, print it out, has to be notarized, but you can print it out and fill in those things, okay? So yes, I do that all the time.
I'm sorry.
Go ahead.
So how does that compare for someone with Alzheimer's? What are your...
We're going to get there. Perfect question. Perfect question. Because the problem we have is that someone with Alzheimer's can be anywhere from mild to severe. And capacity is not, in healthcare, I talk to doctors up at uni all the time. We have this argument all the time. Lawyers are always right. And if you don't think I'm right, go back to number one. But no, doctors, and I understand this, medical people look at the patient now. We look, are they in immediate danger to themselves or others? Can they cognitively tell me what's going on right now? 30 seconds from now, they may not be competent, but right now, are they competent? Attorneys and courts look at a historical ability to make decisions, and we'll talk about that, okay? So here is the power of attorney you can download from my webpage. It's the same one from the state of Utah, all right? Right down here, what does it say? Second page. This power of attorney is effective immediately unless I have stated otherwise in the special instructions, which are right there. Okay, so is it durable or is it springing?
Durable.
It's durable, good. Okay, unless they turn around and say, you can say, they could put in instructions in there that says, when my doctor says I can't make decisions for myself, boom, okay? Or I put in mine, the doctor who, my primary care doctor or my doctor who has seen me in the last 30 days. Because I know how hard it is to get 2 docs. If you've got a patient that's in a care center, getting 2 doctors there is kind of hard. By the way, nurse practitioners count. Physician's assistants, PAs don't. Okay, don't ask me why.
Can you say that again?
Doctors are okay. You can use a APRN who's seeing a patient. following the patient. Their opinion counts. Physician's assistants, PAs, don't.
How about a DO?
DOs definitely. In Utah, DOs and MDs are exactly the same, okay? But try to tell that to a judge. Sometimes I go, what's a DO? But yes, under DOPL licensing, DOs and MDs are treated exactly the same. Okay, good question. Designation of a successor person, so you can appoint someone. You can go through and check exactly what you want. So the patient can say they can sell my real estate, we can do estates, trusts, and other beneficiary interests. That's really important because someone who is doing life care planning, someone that's going into a care center and we have to worry about protecting their assets in a 60-month look-back period to get them into new choice waiver, we got to be able to set up a trust for them. So that's an important one that we check. Okay, they sign it. They nominate their conservator and guardian in there. Back up. The most important thing is this has to be notarized. An advanced healthcare directive, living will does not, this has to be notarized. That's the hardest thing in the world, trying to find a notary in a hospital, especially at about 4 o'clock in the morning. The neat thing about the U is all their directors of nursing are notaries. So the shift supervisor is a notary, normally up at the U of U. So I can go up there at 3 in the morning, God forbid, and I can get one. But because I don't like looking for them, I went out and got my own notary. Yes, ma'am?
I did both at the same time, the living will and the Durham Star, and that's why I had the bank, because they notarized it and they signed my witnesses, and it was all done, both documents.
Perfect. And that's exactly what, if you can get your caregiver to go to the bank or the credit union, great. That's the way to do it. And you can print these for free, so you don't have to worry about trying to find an attorney. Now, there are some places, Fidelity Investments is one of them. Schwab is another. They tell you all this all the time. They'll only honor their own POA. And they'll turn around and they'll say, and I love this, you'll get Wells Fargo. Anybody here from Wells Fargo? We can badmouth them? Okay. Wells Fargo Bank is one of those frustrating people. I know their legal department, they're very reasonable. But that poor person who's done the training that's at the branch, it doesn't trickle down. And you'll get somebody at the branch and they'll go, no, you have to fill out our own POA. And I go, I'm sorry, they're not competent. That's why we're here. Well, no, you need another POA. And I'm going, but they can't sign. They don't care. They want an incompetent person signing their own POA. Legally, you can't do that. I get them where I've got a guardianship and a court order signed by a judge. And they go, no, we want you to sign our POA. And I'll go, why don't you go down to the court and explain to the judge why you're not going to honor their POA? Okay, everyone. Go ahead.
Utah power of attorney, if you move them out of the state.
Still valid. Good question, Nick. Still valid. Yes. Under the uniform probate code for the entire United States, every state honors another state's POA if it meets within their guidelines. But yes, it's transferable. Okay? Every one of us. Yes, sir.
Just one quick comment. Having been through this, protect and save that original copy. A lot of times people will accept copies of the POA, but there are some instances that they want the actual original.
Right.
And so protect it. Put it safe.
Yes, I always, if I can get the patient and they're competent, I'll have them sign 2, and I keep one. I call that my coffee insurance policy, because I know you're going to be looking at it someday and spill coffee on it. Okay? And so I always do, but I always scan one and put it in the cloud. But yes, you are correct. Everybody who owns property in the state of Utah needs to do this. There's a scam going out around, and it's been going on, and mostly with elderly people. If you own a home, what someone will do is they'll go down and they'll record a quitclaim deed, they'll forge a quitclaim deed, and record that against your house. It will show that they now own your home. They will then go out and get hundreds of thousands of dollars of loans, get a mortgage or a second mortgage on your home based on the fact they now own it. And then when the bank 10 months or a year later comes in and tries to foreclose on your home, you have no legal standing. You lose your house. Yes, that's how shocked I am too, because these elderly people, you talk about scams. That's the #1 asset we all own. Okay? So what we do, And you can see this, especially on the late night. If you ever go to like CMTV or some of the, like the Hallmark channel after midnight, someone will say, you pay us $200, we will protect your home from fraud. You don't have to pay $200, you can do it for free. You go to the county website. Most counties here in Utah do this already. You go to the magical, this is the county website, okay, for Salt Lake County. Utah County does it, Weber County does it, Davis County, so everybody across the Wasatch Front. You click the Property Watch button, okay, which is this website right here. And you go in, you go ahead and get that. You go in and you fill in these little lines. Salt Lake County address, your name, your email is very important. You don't have to worry about the parcel number, it automatically will fill in. You hit this nice little blue button at the bottom, oops, sorry, it says apply, and anytime anything gets recorded against your property, you get an email. So do that for your parents, do that for yourselves. This is everything you need for the bare minimum. We all need this. This is your 72-hour kit for legal 72-hour kit. Now we're going to talk about your 2-week disaster plan. So if you've done this, then let's go to the next level. Let's talk about wills in Utah. You need to have a will. Why? Because you don't want your kids fighting after you're gone. They fought enough while you were alive. Okay? We're going to talk about how to pay your bills. We're going to talk about what you need to do. Okay, so first of all, what if you don't have a will? What happens? Goes to probate. What's probate going to do? Then you're just going to keep it all? No. There are intestacy laws in the state of Utah. If you're married, and this is where we get in trouble, if you're married and you pass away, you don't have any stepkids, it's your first marriage, okay? Everything goes to the spouse. It's that simple because the state assumes that's what you would want to do. However, you get that nice, sweet person that goes to the nursing home, they find the love of their life, they get married, and 6 months later they die. Half of everything they own goes to the spouse. And their kids, who've been taking care of them, get half. So unless you have a will, that's what happens. That's why I'm saying everyone needs to have a will, especially if you've got a second marriage. You want to see a fight? See what happens when the spouse dies and the new spouse has a spousal right to a home share account in their not just their home, but they have entitled to up to 1/2 the value of the estate. And kids and stepkids, and it just causes the biggest fight you ever have. I make lots of money on this. My wife says this all the time. An ounce of prevention is worth about $20,000 in attorney's fees. Okay? So, you want to designate somebody to how to pay your bills. You want to make sure you know passwords, accounts, web pages, Facebooks, your social media. Tell your kids how to do this. Or put it someplace where they can find it. Or if you're a caregiver, ask them. Ask your mom and dad, Mom, I'm not going to do anything, but I need to know how to do this stuff. And this is, if I tell you anything today, the one thing, my greatest pet peeve of all, even more than advanced health care directives, is joint owners on accounts. How many people in the room right now are a joint owner on your parents' account? Okay, most of us. We do that all the time, right? How many of you have done that with family members? I'll put you on as a joint, okay? Don't. And I'll tell you why. Liability. Exactly. Okay, let's see if we get there. We talked a little briefly about this cute little jack-in-the-box and springing powers of attorney. When you talk about joint owners on accounts, I want you to think about this jack-in-the-box. Okay? It's that scary. I show this to my daughter who hates clowns. Is scared to death from this. If a child is jointly on a parent's account and that child has to, first of all, that child can take the money and use it themselves. Well, I'm not worried about that. Well, what happens if the child gets in a car accident and gets sued? They can go after mom and dad's bank account. What happens if they file for bankruptcy? The bankruptcy court will demand that you list that on there. It's an asset in the bankruptcy court. You go through a divorce, try to explain to a divorce court when the new soon-to-be ex-spouse is in there going, well, he's a joint owner on this account. So don't do it. And plus, everyone thinks, well, you know, my daughter, she's the most honest person. She would never do this. The minute you die, she owns the account. She has no obligation to pay that to anybody else, nor does she have to use it to pay your bills. It belongs to her. So don't do it. What do you do instead? You want to designate the child or your estate as a POD, payable upon death, or a TOD, transferable upon death. You go to the bank, if you want the kid to be able to pay your bills, do a power of attorney. It's still your account, but now they have a fiduciary duty to pay your bills. The second thing is that if you make it a TOD or a POD, when you die, then the money goes to that person. But if you want it to go to other kids, name your estate. Instead of saying it belongs to my daughter, say it belongs to my trust, or it belongs to my estate. Yes?
What if you've opened an account for a child when they were a minor and you've just never taken that account out? Is that considered jointly owned?
Yes. Yes. Normally divorce courts look at that, but technically, yeah, in a bankruptcy, you would have to go in and litigate the issue of who put that money in, whose is it? Okay, so yes.
You talked about the POD or the power of attorneys. Do you maintain, or can you talk about, is the standard for maintain authority for the principal to act on their own and the attorney in fact to act for them at the same time, or giving up all those rights with the standard?
You can put that in the special instructions. And I put in there in consultation with me, but normally the problem with the power of attorney is you don't give up your rights to make those decisions. You just grant those rights to go to someone else. So if you have Alzheimer's, and it's almost like playing soccer, whoever's got the ball is winning. So the kid who wants to manipulate mom and dad takes them down to the bank and they put them on the account. And so the good kid who's trying to protect mom and dad, they go in and they change that. And then they turn around and get the power of attorney. They take that down to the bank and they hand it to the bank, and the bank says that's great. And then the kid that wants mom and dad's money takes mom down to the bank, and mom just pulls the money out anyway. So until you protect the account, mom has as much access to the account as the power of attorney or the agent. Does that make sense?
Yeah, so I guess that's the next question. At what point do you look at and say it's time to make it exclusive?
Right. That's usually a conversation you have to have with the legal department. And most banks will turn around and they'll start seeing a pattern, but unfortunately you can see kids. I've got one right now where we're litigating over the issue of about 10 grand a month that one kid is going down and taking out of the bank account with mom. Yeah. So yeah, that's when normally that's when you have to get a guardianship and a conservatorship to protect the account. But you can, as a power of attorney, you can at least go down and freeze the account. Yes, ma'am.
So just to be clear, because I'm not super clear, like she was saying with the minor, if I'm a joint on my children's accounts, they don't have access to the separate accounts that they're on.
No, they don't.
So if something happens with their money on their account, like bankruptcy, they can't then attack your own separate account.
No, but the bankruptcy court can take, where you end up in trouble is if you're going through a divorce, the divorce proceedings can go after the kid's account, okay? And if it's anything like my kid's account, sometimes they have more money than I do. Okay, joint tenancy on property, same thing. Let's see, we get tenants in common. You know the difference between joint tenancy and tenants in common? Just real quick. Tenants in common, you each own half. So if you have 3 tenants in common, you each own 1/3. So when someone dies, and I just did this with a couple out in Riverton, when someone dies, you have to probate that 1/2 of the property in probate court to get it over to someone else. That's tenants in common, okay? Joint tenants, you each jointly own the whole property. So when one dies, all I have to do is go down to the county recorder's office, record the death certificate and an affidavit, and now the sole remaining owner owns the whole property. I don't have to probate. It's a huge advantage. Another huge advantage right now is with a joint tenant, if you're married and you bought the house and it was $30,000, 40, 50 years ago, and now it's $1.5 million, when the first spouse dies, the remaining surviving spouse gets a stepped up basis in the capital gains up to the current value of the house. So they only have to pay capital gains when they sell the house on half. The other half, they don't. So there's a huge estate planning advantage to that. Disadvantage is if it's with your kid can go out and get a loan against your house if they go through bankruptcy. All the same issues that Nick talked about with creditors. So that's the disadvantage of that. They could sell it. I had a kid down in Utah County that went out and sold mom and dad's property and didn't tell him. He needed it. He was in trouble financially. We found out about it when they started to foreclose. Okay, so now we're going to talk about a 3-month supply. All right, I talked about what you need as a bare minimum. We talked about having a will. Now let's talk about trust, pour-over wills, and medical POAs real quick. And then we're going to talk about how do we use all this, okay? And then we'll talk about long-term disaster planning. Life insurance does not help you, it helps your kids. So when you get old enough, it's great when you're trying to make sure your wife and your kids or the primary wage earner is going to be taken care of if the primary wage earner dies. But when you get to be, 65, 70, you don't really, unless you're using it as a whole life way to save money, you don't really need it. What you really should look at before you do life insurance, when you get to be in that 50, 40-ish range, long-term care insurance. And we'll talk about that. I read an article the other day that those of us who are in that magical age between now and retirement, so if you're in that 60 to 65 age, does anyone know how much your average out-of-pocket expenses, this is with Medicare, how much you're going to pay out of pocket for the remainder of your life, the average? $385,000. That's with insurance. If you have a spouse, that's $700,000. And that doesn't include long-term care. So if you need long-term care, you could lose everything. So I'm a big fan. If you're doing long-term care planning, talk about life insurance and stuff like that. So we talked about all this. We're going to talk about trusts, pour-over wills, medical POAs, and investments in retirement. But now let's talk about the game of life, okay? Or what I like to say, plan now or pay later, okay? These are all true examples. You live alone. You were recently diagnosed with stage 4 lung cancer. Do I have any doctors or nurses in the room? What does stage 4 lung cancer mean?
Death.
Yes, death. You're going to die, okay? Prognosis is poor. Your doctor advises you to get a post form. Your family attorney already prepared a revocable family trust, a will, a medical durable power of attorney, and an advanced health care directive. They did everything they told you to. Why do you need a post form? Anybody know the difference between a post form and an advanced health care directive or a living will? Yes.
I think
Go.
So the post has more details of what you want done in certain scenarios,
They can be exactly the same wording, same everything. Okay?
I think the post is what, like if an EMT gets called,
Yes.
you have to hand the post to them because otherwise their protocol says, sorry, we've got to do what we've got to do.
Yes, exactly. That's the difference. So if your mom or dad or loved one is in a care center, or if they're on home care on hospice, and this has actually happened. I was a police officer, believe it or not, before I was a respiratory therapist. So there's 6.5 years I was a cop. I was the first guy through the door. They always tell police officers, if you're the first guy through the door, keep driving around the block till the EMTs get there, okay? But I was stupid. I was ACLS certified, so I was always the idiot through the front door. But yes, what happens is a post form is a doctor's order. And by the way, post forms can be filled out by either physicians or nurse practitioners, not PAs. I think they're trying to change that right now. But a post form, if you're standing, so mom's at home, mom's got end-stage lung cancer, mom's dying, she's scared, she's short of breath. Well, you don't know that. You don't know. What do? You dial 911. Paramedics get there, and by that time, mom's fully coated, she's turning blue. Okay? You go, this is God speaking to you. Let her go. The EMTs walk through the door, and I've had a daughter stand there with an advanced health care directive, living will, right there going, she's got a living will, don't start CPR. What are they going to do?
Start CPR.
push you out of the way and start CPR. Without a pulsed form, especially if you got somebody in a care center, that little CNA goes in to give breakfast and mom's totally coded, been there, done that. They have to start CPR without a pulsed form. So you go to my website, you can print a pulsed form. I can't fill it out for you, but you take the mom and dad to the doctor and fill out a pulsed form. And there's instructions and everything right there, okay? That's why you need a pulsed form, because we don't want to see this, having done that more than once, okay? 9 years ago, before your spouse passed away, the two of you prepared a trust, a will, powers of attorney, and you were recently diagnosed, listen to these facts, with Alzheimer's. Your symptoms are mild, but your doctor wrote a note, and he thinks you should no longer drive. The doctor's staff called your son, who is your financial power of attorney. Listen carefully, okay? Your son sold your car because you can't drive, sold your house because he has to pay for your care, moves you into a care center close to him, clear up in the panhandle of Idaho, okay, and doesn't think that you're capable of managing your finances or making good health care decisions, and he took away your debit and credit cards and will not let you spend any money because he's worried about caring for you. Plus, he also wants to make sure there's money left for him when he gets all finished. Okay? Can he do this? Yes, no, maybe. The answer is always maybe. Okay? I tell this to everyone. If you ask an attorney a question, the answer is always depends. Okay? Depends on what you want. If you ask an attorney his favorite color, do you know what that color is? Plaid. Okay? So, it depends. It depends on what the POA says. If it's a springing power of attorney, no, he cannot. If it's a durable power of attorney, he has the authority to do it, but you've only got mild Alzheimer's disease. You have to act in the best interest of the principal, your mom. He does not have the right to override what mom wants. Mom wants to live with her daughter, not the butthead in Idaho. She certainly doesn't want to live in a nursing home. And as long as she's medically capable of doing so and it's medically safe, she has a right to dictate what happens. So who tells the son no? She can revoke the POA, and he says, I don't care. Go ahead and revoke it. I still have it. Okay, you as a health caregiver do not honor that POA. If you're working with that patient, get a hold of the bank and let the bank know that POA has been revoked. Contact an attorney and revoke it in writing. But you got to revoke it because this guy nearly bankrupted this woman before she could get the money back.
So if you have a POA, your parents are leaving the POA, you don't have to wait until, you don't have to show competency? I mean,
If it's a springing POA, you have to show competency. There has to be a springing event. But if it's durable and you have that POA right now, which most of them are, you've got that authority right now. Okay, but you still need to talk to mom and dad. The problem you get is when you're dealing with someone with Alzheimer's, is that when you start talking to mom and dad, they don't understand what it is that they want. We'll talk about that in just a second. Okay? There's different levels of capacity. Some are related and some are not. Incapacity is a legal finding. So you as a health caregiver do not have the authority to say they're incapacitated. That's a legal finding. That judge has to say that. We can all go, oh, that patient's incapacitated. They don't have capacity. They may not have the capacity to drive. They may not have the capacity to financially make decisions. They may still have the capacity to do a power of attorney, or they may have testamentary capacity to do a will. They may have the ability to write you out of their will. Okay, and they do that all the time. Fine, I'll just take you out. Okay? And then you go, fine, I'll just put myself back in because I have a power of attorney. Determination by an MD that a patient is unable to give informed consent is different than incapacity. Okay? So for us to get a finding of incapacity, we have to either pink slip them, blue slip them, white slip them. We got to do something, or we need to file a guardianship. Okay? Ability to carry out specific tasks. So you may not be able to operate a motor vehicle. By the way, if you have concerns about a loved one, everyone says go get a DMV. you know, most of us can close our eye, put one arm behind our back, and pass the DMV test, okay? I did. I mean, I'm blind in one eye, I did. But you don't have the ability, if you get a good occupational therapist that will do an evaluation, they look at, can they safely get in and out of the car? Can they make decisions on how to park? They look at not just their driving pattern, but other things. Can they find their way back home? So I always tell, if you've got a concern about a loved one, get an order for an occupational therapist to do an evaluation. The U of U Senior Clinic has fabulous resources. But that's where I would tell you to go before you send them to DMV. And they said you can go take the DMV test as often as you want. You can also ask mom to go back as often as you want too. Okay? And it's anonymous. If you have concern, you want them to test, you just notify DMV, they'll bring them in. Okay? So, financial capacity to perform ADLs is different than financial capacity. Keep in mind, doctors and healthcare providers look at black and white. Do they have capacity or do they not? We in the medical or in legal, because our favorite color is gray, we look at a continuum of a historical ability, okay? So we'll talk about that right now, because I'm running out of time. 20 years from now, this is a quote, by the way, this is now 10 years old quote. 20 years from now, we will look back on our failure to protect the assets of vulnerable older adults with astonishment in much the same way we look back on allowing 8-year-olds to work in factories and doctors to sell patients cigarettes. You realize they prescribed cigarettes in the 50s to people so they could lose weight. Okay, they did. It worked. They lost weight. And if you get stage 4 lung cancer, you lose lots of weight. Okay? But yeah, that's true. We fail to protect. To what degree do we fail to protect? 70% of U.S. wealth is held by baby boomers and seniors. That's a scary thought. Okay? That is very applicable. 70% increase in Alzheimer's and dementia is expected in the next 10 years. Not because it's worse, but because we're getting that age. Not you guys, me. Okay? So 70% of the wealth is held by people who are becoming incapacitated and incompetent. 22% of Americans over age 70 have mild cognitive impairment. So almost 1/4 of everybody over 70. Okay? 1 in 3 seniors will die with symptoms of dementia. Only 1 in 35 to 44 cases ever gets reported to Adult Protective Services. It's that underreported. That means that there was a 74% increase, this is Utah APS, 74% increase in the number of cases reported to APS in just between 2011 and 2016. I pulled these numbers from a caseworker at APS. They gave them to me, okay? And that 74% is only catching 2 to 4% of actual exploitation of adults. Huge.
Is it like when you report for child abuse?
It's exactly like. So if you're a
not sure what that is.
if you're a caregiver, what's the standard? If you're a caregiver, what's your duty to report? If you have reason to believe, that's what the statute says. Okay? It's mandatory if you have reason to believe. You don't have to have proof. If you're concerned, that's enough to report. Okay? If a kid will not give you bank statements and you're a caregiver, if they won't turn in their new choice waiver application because they're afraid to give the bank statements, that's a reason to report. If they won't sign a no-code, I did this when I worked at Promise Hospital. We had a patient that would not sign a no-code for their mom because he was living in her home. And for him, if mom dies, he loses mom's Social Security. He loses his place to live. So he's keeping her on a ventilator, on life support for 80 days because he does not want mom to die, because if she dies, he loses his money, or he loses her money. Is that a reason? Is that exploitation? That's the worst kind of exploitation. So yeah, the neat thing is I found out he was on parole. So I just kindly mentioned, I have to report this to Adult Protective Services, and they have to cross-report with your parole officer. Boom, sign that no code the next day. Okay?
So they're taken seriously.
Oh,
Things like
yeah.
financial neglect and things like
Oh,
that.
yeah, absolutely. Okay? In Utah, state study states the cost and victims' losses are estimated between $48 million and $110 million annually of exploited adults in Utah. In New York, 1.5 billion. Okay, and these are old stats. 2 out of 3 abusers are family members. Who's the third one?
Scammers?
Huh?
Scammers?
Healthcare providers. Their primary caregiver, that sweet CNA that's going in and giving them a bath, they want to turn around and give them a college education. They can't do that. Okay? Scammers are a huge issue also. But the normal number one person to abuse or exploit mom or dad is the primary caregiver, which is really sad because they don't understand that they're doing it. Most kids don't. Okay? Any person who has reason to believe, you have to report. If you're if you're licensed by Doppel and you don't report, it's a Class B misdemeanor. You'll lose your license. Okay? And you report, you shall immediately notify an APS or the nearest law enforcement agency. Okay? That's where you need to report to. All right, you're 64 years old and your spouse and you own a business. You've worked your entire life. You've just sold your business. You have enough money and investments to maintain your lifestyle for the remainder of your lives. Your spouse has just been diagnosed with early onset Alzheimer's. It is progressing rapidly, and your spouse will need to be placed into long-term memory care within the next year. Congratulations, you're broke. What are you going to do? Okay? As a health care giver, get that patient in to see an elder law attorney immediately. Because the neat thing is if you have early onset Alzheimer's, you may be able to protect all those assets for that other spouse. Don't wait. If you've got somebody that's got a diagnosis or they're concerned, get them in because we can set up trusts. We can protect that money. We can start the 5-year look-back period so that we can protect that so eventually they may be able to pay for their long-term care. I'm more worried not about paying for the long-term care, but leaving enough money to take care of the community spouse who doesn't need long-term care. Okay? We don't have time to talk about this, but basically we would break it down and we would help them. Let me get down to this one here. You don't need those. We don't need that. You do, but we don't have time to talk about it. Protect versus exempt. Okay, you get that one kid that quit their job and they're staying home with mom to make sure she's okay. And mom needs to go to a care center and Medicaid's going to say, well, you have to sell mom's house. Are you in that situation ever? There's a statute that says you don't have to, okay? You can transfer the house to a spouse. You can transfer the house to a child, not a grandkid, but a child who has lived in the home and helped mom or dad for 2 years. You get a doctor to sign an affidavit that says, based on their care, we've kept mom out of a care center for 2 years. That's not hard to do. Let's face it, that's exactly what we do as caregivers. If we can do that, we can exempt the house, we can have it deeded over to the child, and they'll qualify for Medicaid. So don't say, oh, you got a house, you got to sell it.
If the house is in a trust.
If the house is in the trust, it depends. What's the answer, Nick? It depends, okay? It depends on what kind of trust. A lot of people say, well, I put it in a house, and if you didn't have it done right, it's not protected. But if it's put in an irrevocable asset protection trust, it's protected. So that's why you want to make sure, even if they have a trust, if you've got somebody that's got a diagnosis of Alzheimer's, have them contact an elder law attorney. Not somebody that just does trusts and estates, but somebody that does elder law, that understands Medicaid. Because we can flip that, we can amend that trust to an irrevocable trust and start the 60 months, 5-year look back. So we can protect. And if we can't do all of it, we can at least protect half of it. So there's things we can do. All right? This is the difference. If you don't have a trust and you don't do that protection if you have an asset protection trust, I can get them qualified for Medicaid immediately. I can pay for their care. So instead of being in that double room with a shared bathroom on the ugly side of the hall. And the reason I made this green is that actually the care center where I worked, that was the color of the patient's walls. Okay? So it's what affectionately I call gas chamber green. It is, by the way. I'm sorry. But if we get them into a trust, we can protect the assets, move them to a private room overlooking the rose garden, and only have to pay the difference between the Medicaid rate and the private rate, which is usually only about $50 to $60 a day. Okay, versus having them spend everything down, have nothing left for the community spouse, and then have them qualify for Medicaid. Okay, so that's the big difference. All right, now we're going to talk briefly, where are we time-wise? Okay, we're going to make it. Your sister is 50, well, this actually is a true story. Your sister is 51 years old, single, has a good job, owns her own house, is independent, and has been estranged from the family for several years. You get a call from the case manager. This actually was at IMC, okay? She's had a major global intracranial bleed, which is a nice way of saying a massive stroke. She's on a ventilator, she's intubated, she cannot communicate. You go to her house and you find out that despite her independence, she's in serious debt. Her home and car payments are several months behind, and you're on the verge of foreclosure. What are you going to do? You got that look like run like, yes. That's an option. It's a good option. But if you really want to help, what are you going to do? Anybody?
Call you.
Okay, call me. That works. There's an option, okay? You need a guardianship. How quickly can you get a guardianship? 24 hours. I can get you appointed in a guardianship in 24 hours. If it's Salt Lake County, yes. The further I get away from Salt Lake County, the harder it gets. And the reason why is the system's different. It's not because of judges or anything else, but in Salt Lake we have one judge who signs every single guardianship. So I call his clerk, I email Katie, and I can get you appointed by tomorrow. And with that, you'll have the ability to go in, pay her bills, apply for Medicaid, start the Social Security disability application, stop foreclosure, open up bank accounts. You can do everything, okay? And you can make decisions in regards to long-term care. You can get her admitted to a care center or rehab center. Without it, how many people work for Alzheimer's or rehab units? Can I get a patient admitted into an Alzheimer's or a care center without a guardianship or a POA? No, they will no longer take you. So unless you've got one, I get calls all the time from care centers. Kent, I need a POA right now. Okay, and I tell them, look on my website. But they have to be able to have capacity. Do they have the ability to sign? And if not, you get a guardianship. Because with a guardianship, I can do everything. The difference between a guardianship and a conservatorship is over their stuff, their money, applications, Social Security applications, all that. Guardianship is over them. Do I start a tube feed? Do I not? Okay? The process is exactly the same. The cost is exactly the same. So I always ask for both unless the person has no money. Okay? The legal definition for me to get a conservatorship, I have to show that a patient is unable to manage property and affairs effectively because of mental illness, physical illness, chronic drug or alcohol use, and they have property that would be wasted. When I teach the social workers up at the VA, I ask them, do you have any patients at all that don't meet this criteria? If you had active service, if you were an active service vet, you've got all of these. Most of the patients at the VA qualify for a conservatorship. If you're having trouble managing the patient's funds because they don't have enough money at the end of the month to pay for their long-term care, conservatorship's an option, okay? Uh-oh, we must be done. There we go, okay. Factors the court may considering and we went too far. Guardianship. Incapacity. This is what a judge will have to find. They lack the ability, even with technical assistance. So even if I have home care coming in, even if I've got meds being set up, even if I got someone monitoring their meds, they cannot, and the word is consistently, receive and evaluate information, communicate decisions, provide for food, shelter, clothing, okay? So a lot of people we can get qualified for a guardianship, even a partial guardianship. Okay? Unable to govern themselves and manage their own affairs. They lack realistic understanding of nature and extent of their impairment, and they have no plan for the future. So, I want to go home. Is that a plan for the future? No. You've got that Alzheimer patient or that dementia patient or somebody that's just old. I want to go home. How are you going to take care of yourself? I can take care of myself. Okay? So look at this. This is probably where a guardianship is appropriate. I just did one where this came out of Lakeview Hospital. The patient had gone to the ED 3 times, fallen down the stairs, poop all over themselves because they can't toilet. And they go, I want to go home. And I get a call from the case manager, Kent, what do I do? I go, you should have called me two admissions ago. But we could get an emergency guardianship. And that's what we ended up having to do. The problem was they'd get him stabilized on his meds, they'd send him home, he can't take his meds, he decompensates. And the good thing is we didn't find him at the bottom of the stairs. Okay? I had a patient at a care center. I love this woman. She was sweet. She's diabetic. She's got dementia. She's having trouble. She's got diabetic ulcers. And we're doing wound care on her. And she says, it hurts when you take my bandages off. I want you to treat my ulcers, but don't take my bandages off. Okay? And you're going, I can't do that. No, treat my ulcers, treat my bandages, do my wound care, but don't take them off. And the nurse would send her to the ED to get her admitted, and the doctor says, she's competent, she can turn around and tell me no, and send her back. And she's getting sepsis. And we're just going back and forth and back and forth. You don't have to play that game. Get a guardianship appointment so the guardian can say, take the bandages off, treat the pain, because that's what really she was complaining about. It hurt. Do pain management, and let's treat the patient. Okay. Consistently, we look at the historical pattern. We look at this with patients. I do this up at uni all the time. We look at executive functioning, the ability of them to consistently. So patients, you got that patient that's had a long, long history of bipolar disease, but now they have FTD, they got frontal temporal dementia on top of it. Oh, it's a bad because they're like this. It's like riding a roller coaster. I tell family members, if you have to deal with someone like that, stop and get a conservatorship and a guardianship. I said, I can't keep them off the roller coaster. You're still going to have that problem. But I can at least put you in the same car with them. So when they're up, you can follow them. When they're down, you can follow them. You can help them stay on their meds. So you're not running behind the roller coaster trying to catch up and manage them in retrospect. Okay? So we won't talk about that because we're out of time, even though it's a fun picture.
Can I ask one quick question?
Yes.
You said we should or could get both?
Yes.
Be designated as a guardian
And a conservator. Or we can get one kid and another kid. Okay? And what happens if you have no family members? Depending on assets, we may be able to get somebody appointed. Has anyone ever tried to get the Office of Public Guardian appointed in a case? It takes 6 months before they even look at it. They're that backlogged. Love them dearly. They're fabulous.
So is it good to have guardianship plus a POA?
No. And this is where I argue with Wells Fargo all the time. If you have a POA and you need to get a guardianship, the guardianship trumps the POA. And I'll get people from the bank, they'll say, well, no, we need a POA. And I'm going, I got a frickin' court order. Okay? And they go, well, we want a POA. And I said, read the court order and follow it, or I will do an order to show cause and have you go explain to the judge why you're not. Okay, so what do you do? What's the one thing I can help you with? Talk about it. Talk. Talk to case managers, talk to social workers, talk to family members. If you've got a family member, talk and plan now, because an ounce of prevention is worth about $20,000 in attorney's fees. Okay? Social workers, professionals, interact with each other. There's a booklet that's floating around here. It's got resources on the back. It explains a lot of this stuff. I will come out and talk to a family member for free. If you're a healthcare provider and you work for a facility or a home care agency and you've got somebody, call me. I'll talk with them. We'll do a Zoom conference for free. I don't charge them for that first visit. If they say so-and-so from hospice referred me, I'll talk to them. It's okay. I would rather do that and fix the problem quickly than have you guys have to deal with it for 6 months and have the patient injured laying at the bottom of the stairs. Okay? Any questions? I'm sorry I went over.
Do you need a durable power of attorney
The problem with the power of attorney is great, okay? And if you have one, it makes things much, much easier. But what sometimes happens is you get the power of attorney and then the patient gets paranoid. They're stealing my money. No, I can't do that. I'm not going to take my medicine. I'm not going to take my meds because you're trying to poison me. And by golly, you are, because you're putting their meds in their applesauce. Okay, so I know you're trying to poison them. But because what happens is the paranoia sets in, they're not logically thinking. They have the ability to revoke the POA. And that's where you turn around and go, I've got to get a guardianship. Because then the guardianship trumps and overrides it. I get the calls all the time from Salt Lake Regional Hospital, their senior behavioral health. I got a patient in here, they're paranoid, we got a POA, but they won't take their meds, and we've got to. I had a sweet, sweet lady who got a call. I got the nicest card from her just recently. But for 6 months, she was sleeping in the backyard because she was paranoid that there were people breaking into her house. Her kids had a POA. They could not get her to take her meds. The doc called me. He's a geriatric psychiatrist. What do? We get a guardianship, and we put right in the guardianship, you have the ability to force the patient to take injectables. So once a month, the kids would take her in. Mom, I'm sorry, we either have to admit you to the hospital or you have to take the shot. We did that for about 3 months. She's been on her PO meds for 2 years. And she's happy, and she's stable, and she's doing okay. But the minute she doesn't, the kids have the authority to go in and take her and admit her without having to go to have her blue slipped. Okay? Other questions? I'm sorry, Nick, he's in front, I'm sorry.
Can you talk briefly about the 60-month rule?
The 60-month rule is for qualifying for New Choice Waiver Program, for Medicaid, okay? So to qualify for Medicaid, you have to have less than $2,000 in assets, okay, and income. So what happens if they get $2,500 a month? That's not enough to pay for long-term care, but it puts them over the New Choice Waiver. Well, that's simple. We still start the application for the New Choice Waiver Program, and we have to do them spend down. So the first $2,000, or the first $500 they spend, and the rest of it, they spend it by paying towards their care, and then the rest of it Medicaid kicks in. Does anyone know how long it takes to qualify for New Choice Waiver? Anyone ever tried to do that? Okay, the statute, it says 1 year. The reality is it's about 18 months to 2 years because of the backlog. So there's 2 ways to get past, or to qualify for New Choice Waiver. One, they go to a skilled nursing facility. Skilled nursing, not an assisted living. They go to skilled nursing under some medical need. Wound care, physical therapy, they've fallen, they've broken their hip, they need re-strengthening because they've been laying in bed too long. I keep them there for 90 days on Medicare, and then they have less than $2,000. We can flip them to New Choice Waiver, get them on Medicaid, and then puts them at the top of the list, and I can get them over into a care center. So that's number one, 90 days in a SNF. The other way is you have to go to a skilled nursing center and pay out of pocket for 1 year. So you get them, you get on that list, you get in your blue book or your senior resource book, you find a care center that is somewhat affordable. The last one I saw was $4,500 a month. You have to get a reverse mortgage on the house or something. But when you get them in the care center, you pay out of pocket for a year. We protect the rest of the assets. We move them over into a trust. Okay, and then when that 1 year of paying out of pocket's up, then you can flip in the New Choice Waiver. The New Choice Waiver looks at any transfer, this answers your question, any transfer that you've done in the last 5 years. So mom says, well, I got Alzheimer's, I gave the house to my kids, and now I can apply for Medicaid. No, Medicaid will look at that transfer as for less than that market value, and they will ding you. And basically, let's say you gave the house and the house was worth $400,000. Okay, they'll look at that as a $400,000 asset. They will divide that by $6,900 because that's the average cost of care, and that will tell you how many months that you have to pay out of pocket before you qualify for Medicaid. Don't even worry about trying to do the math on that. It will boggle your head. Just call an elder law attorney. There's also other people. There's a couple of agencies that will help patients qualify. We used to use one when I worked for Avalon Healthcare. We call them and they would tell us whether or not we could take a Medicaid pending to see how long it would take to flip them into Medicaid. But there are people who do that.
So what do you do if they do have a house?
We flip it into, put it into a asset protection trust. We transfer it to somebody on that list of preferred people. We transfer it to a spouse. We can do stuff. Medicaid won't take the house as long as the patient's willing to come back and live in it. So you just have them sign an affidavit. Or if a spouse is living in it, but what they'll do is they'll put a lien on the house so when the patient dies and the spouse dies and the kid that lived in it dies, they get paid like in 20 years. Okay, but they don't count the asset. There's things we can do. Yes?
I'm sorry, Ken.
You're out of here. I'm sorry. I apologize.
I know you'd have 1,000 more questions.
Call
We're
me.
so grateful for
Call me. My number's on the back. Okay?